So the question I asked Sharyn was, what's the difference between criminology and sociology in the law? Is that how you remember my question?
That's how I remember your question. And the way I interpret it is, when you take the criminology out, what's left? And I guess it's a really, I think it's a great question, because I have kind of self-identified as a sociologist of law and never a criminologist. It was kind of interesting to me several years ago when the Australian and New Zealand Society of Criminology held its annual conference in Adelaide, and I gave a presentation there, and a number of people got up and said, well, I'm not a criminologist. So it's kind of interesting, I mean, who and how identifies in a particular way with a discipline. So I've never identified as a criminologist, and I'm not kind of sure why, but I've always been interested in law and the social dimensions of law. And one of the first well, actually it's not the first, but my PhD was on women in the legal profession. And there's quite a lot of scholarship around the legal profession and its recruitment, its power, its status. So I was kind of interested in the legal profession, and there was a lot of scholarship at the time. So this is kind of the mid to late 1980s. And so looking at the institutional and occupational structures in and around law was far more of interest to me than looking at the specific dimensions of crime and justice and those kinds of issues. Another big segment, which I haven't really done much work on, is around civil justice. So if we just look at the kinds of cases that the courts deal with, and much of my recent research, well, really in the past 2 decades, my research has looked at judges and their courts. So much of the recent research, well, some, not my recent research, but there's quite a lot of research that looks at non-criminal dimensions or aspects of law, such as family law, civil law, contract law. A lot of the work that happens, particularly in the lower courts, is around debt and debt enforcement, and that's not criminal law. Mm. So there's, and of course, I've not looked at family law in a, well, not really at all, because I think way back when I was an undergraduate in sociology at the University of Tasmania, the kind of big 2 topics to study, and it was still then a pretty feminized cohort of students, were, you know, family, sociology of family, and juvenile delinquency. So kind of children and family. And I think early on I decided I was not interested in looking at the kinds of things that women were supposed to look at in the context of academia, i.e. things close to their heart, families and children. So I kind of tried to kind of move away from that space a little bit. And, you know, I was aware also of course, in those days, we read Weber in its original form. We didn't read textbooks or summaries or things like that. So we read Weber and Durkheim, and even Marx had a lot to say about law, but it was never really taught. I mean, it wasn't really pulled out. You know, if we were looking at Weber, we were looking at Weber because of what he said about authority and bureaucracy and charisma, or about religion. Really didn't have a lot of time, or we didn't, for whatever reason, talk about Weber and law. And there's a lot in economy and society. There's a lot of discussion about law. Ditto Durkheim, perhaps more in the context of criminal law you could apply Durkheim to, but not only. So I guess, you know, if you take out criminology and criminal law and criminal justice, there's still quite a lot of interest, or quite a lot of leftover, or quite a lot of topics to investigate in law. And it seemed to me, you know, it's one of those things that sociologists are intimately interested in, you know, norms and regulations and values. And yet, as far as my undergraduate experience went, and I understand you can't talk about everything, we didn't look at law. we didn't think about law. We didn't think about the institutions of regulation in a way that a sociologist of law might or does. So I've kind of always been interested in the intersections between law and society.
I have a very clear understanding now.
Good.
I think of what the difference is between criminology and law, a sociology of law. Thank you for that.
Oh, I should add one more thing, I guess, is that I think in criminology, there's a very applied dimension. And, you know, up until recently, where now everyone has to be applied and show the impact of their research and so on, I wasn't so interested in kind of policy recommendations or making things better in terms of the criminal justice system. So there is a very applied dimension to criminology. And I guess I was more interested in kind of the more sociological approaches or thinking about theories that have emerged in sociology rather than the kind of, okay, what to tell the minister about how to fix the problem of, you know, whatever crime is occurring or whatever problem in terms of prison overcrowding or use of weapons or violence or whatever. So I wasn't quite so interested in those issues. But of course now with our interest in, you know, impact and engagement, the policy dimension is much more significant for scholars.
So I imagine, has that changed your research path then, or the research framework?
Not really. And I suppose I can say this, you know, I'm at a point in my career where I'm going to play to my strengths. So I'm going to kind of do what I do and keep on doing that. I think the research that I've been involved in primarily in the past 20 years does lend itself to more kind of policy focus. So as I mentioned earlier, I have done quite a lot of research on judges and courts in Australia and really looking at the role of judges and magistrates in terms of a kind of, I guess, sociology of occupations and professions paradigm. And looking at some of the challenges and some of the issues and some of the things confronting judges and magistrates and the court structure across Australia. And that does lead itself to some kind of more impact-oriented research, because there's quite, in past years, professional education has really developed for judges. I mean, once it was assumed that if you were appointed as a judge, well, that was it. You knew everything that there was to know, and you didn't need any continuing professional education. That's all changed. I mean, it would have been a view of some judges that was a you know, an affront to their judicial independence to have to do continual professional training. Now that kind of idea has gone, and there's a lot of training and programs for judges that have been newly appointed, because unlike the European system of judicial appointment, our judges, and probably everybody knows this, our judges and magistrates are appointed out of practice. So you have a certain number of years as a practicing lawyer, and then you might be appointed to the bench. So there's no specific kind of training. It's just assumed that if you've done any court work or you've practiced as a lawyer, then you will have the appropriate skills to be a judge. Well, of course, it didn't take a genius to figure out that that's not quite the case. So I can keep kind of talking about this, but Sally, you give me some markers, or anybody else give me some markers of things if you'd like me to kind of go in a particular direction or not.
Well, I'm assuming that people have logged on today because maybe they've got questions. So now might be a good time to ask those that are here. I'm just see if someone's unmuting. I can see Dan's on. He's not on mute. Dan, did you have a question, or were you just coming along?
I jumped on to do some lunchtime listening. I have to apologise for missing the first 10 minutes. So my question will have to come with that caveat. But I do have one, if that's okay. I guess this idea of the way sociology can inform the professions of working in this profession more. I do wonder if you have any broader reflections on whether work like that in terms of doing sociology around some of the other professions and the law might be an avenue for the graduates who are coming out of PhD programs now and wondering what routes apart from academia there are for sociologists.
That's a really interesting question, and I'm going to take the opportunity to say kind of two different kinds of things, Dan. So thank you for that. The first one is the question I thought you were going to ask, but you didn't. So I'm going to answer that question anyway. And that is, what do you think that sociology brings to thinking about law? And I mean, I think what's, and I'll just say a couple of things about that. I think what's been quite interesting to me is the way in which concepts which we think of as kind of fairly ordinary sociological concepts, when I have introduced them to legal or judicial audiences, there's a sense of, oh my gosh, this is so fascinating, this is wonderful, this is, you know, this is a framework for us to think about our everyday work. And the two that pop into mind are work-family intersections, and especially in terms of the judiciary, there is a sense among some judicial officers that they're always a judge. So when they walk out of the courtroom door and they go home, that's who and what they are. Among other judicial officers, there's a sense that when they walk out of the courtroom, they become an ordinary person. And so there's there's an attempt for a really strict a boundary between their work and their other lives, and I can talk about that at length, and we've written about that. But it is, and it's a gendered kind of response as well, and so that's kind of really interesting about judicial identity. So when we talk about work-family intersections, and when we first started talking about that, people were, oh, that's really interesting. And, you know, when we talked about other research, which of course the judges and magistrates weren't aware of. And then the other concept, which has been something that I've been working with recently, is that of emotional labor or emotion work, whereas the image of the judge is to be without emotion, to be dispassionate, to be neutral, to be distant, yet achieving that requires an enormous amount of emotion work. And in the court context and in the everyday work of judges, there's enormous issues around emotion work, emotion management, emotion regulation. And just as a little spruik here, we have a book coming out, hopefully in the early part of next year, that looks at emotions and judging. Okay, so now to get to the question that you really did ask, Dan, which is around avenues for graduates. Well, as we kind of discovered very early on in our research, courts and courts administration don't really do research per se, but they do collect a lot of material that's available for research. So they record, which is not surprising, as organizations, they keep records, they record things, they aggregate statistics, provide annual reports of numbers of filings, numbers of cases closed, numbers of people processed through the system. So they actually work with what we would call data, but these are really organizational records. And so they don't have a lot of scope for doing very much with that data. So that's an opportunity for social scientists, depending on the kind of questions that want to be asked. I mean, as many sociologists going right back to, I think, Garfinkel or maybe Goffman talked about the problems of organizational records. and I'm sure that would be an issue that the health sociologists are fully aware of. But in terms of jobs for graduates, there are in kind of in the back door, in the back room, backstage, according to Goffman, there are lots of jobs around kind of managing what happens in the courts and developing policy, and thinking about improving systems. I mean, because it's the courts administration is a part of bureaucracy. I mean, it's a government funded entity, and so there's issues around, like in all organizations, kind of issues around efficiency and productivity and so on and so forth. But in terms of a research role, that might be on a kind of case-by-case basis. I know in entities like the Australian Law Reform Commission, that does research itself as well as commissions research, but that's kind of a very specific kind of organisation. It's not the ordinary everyday working of the courts. So I guess a long-winded answer to the question is that it kind of depends. It is an opportunity for graduates, perhaps not doing research or the kind of theory-generated research that sociologists tend to love. Well, I love, because sometimes theory has to be kind of removed from the discussion or the papers or the reports. The other dimension, or another way of looking at this, is that, for example, one of my PhD students is a judicial officer. So there are people in the courts who are looking to upskill. I have another colleague at another university who is supervising a judicial officer. So they are also part of the demand for higher degrees, if you like. And sometimes, particularly in the lower courts, I guess, that their work is so intense. They have so many cases and have to make so many quick decisions that there's very little time for reflection about their role in the bigger picture, or some of the kind of critical analyses that you might be able to take on board. If you're a scholar or if you're looking at it as a research project, it's very difficult to think about your normal everyday life and the busyness of work outside of just kind of getting through the list or getting through the cases. And so there's not much scope for thinking about this in a broader context. So yeah, I think that would be my kind of take on your question, unless there's a kind of another angle, Dan, that you'd like me to kind of pick up on.
Let's see if anyone else wants to jump in, and then I'll jump in again later on.
Oh, is somebody trying to say something? I can hear some muffled voices, but that's all.
I'm just going to look in the chat.
Oh, I don't see that. So
there's nothing there. And everyone is on mute. So Zoe or Maria, Helen, I'll just call out your names, Leonie, Maricela, Sophie. If any of you would like to ask Sharyn a question, just, Sophie's just unmuted. Sophie, did you have a question?
Sorry, where's the camera? Hi, yeah, thanks for the discussion. Just something that you said about the theory and the use of theory, and when you choose to communicate it in a report and not. I'm an applied sociologist, and this is obviously something that's quite a thing for us. Like, to give you an example, yesterday I gave a presentation to of a couple of thousand hospital staff of the research and didn't mention any theory at all. but so inherent to the work is the theory. So I'm curious if you want to talk a bit about that and about the maybe the decisions and the dynamics about how you choose to bring in and leave out certain things when you're talking with people in the legal profession.
Okay. Okay. Well, I think the issue of theory is a tricky one. And again, this is going to be my opinion, and it might be controversial. Sometimes I think that some sociologists are not very good at communicating the basic kind of ideas behind the theory. So it becomes too grand, or it becomes too complex, or it just becomes too abstract. Now, people in law, judges and lawyers, are pretty concrete. And so if you start to get, and also I should add, are argumentative. I mean, it's the nature of the occupation to disagree, particularly the legal profession. That's just kind of how it is. And so I think part of the issue, and I haven't kind of thought this through really, really carefully, might be the way that theory gets communicated in, and some of our sociological theory is challenging and difficult. On the other side, I think some more concrete use of concepts, which of course all our concepts have origins in theory, such as emotional labor. That has been quite an interesting concept that I've used in the discussion of the everyday work of judges and magistrates. Also, job satisfaction. I've used that concept because, and I use job satisfaction because a lot of discussion around judicial work is about some of the negative dimensions of it, and yet the job satisfaction notion generates positive as well as negative dimensions of work. I mean, I have long realized, and this is one of my early kind of note to selves way back, is that if you look for the negative, the distressing aspects of something, you will find them. But if you don't look for the positive and the rewarding aspects of something, you won't find them. So often pictures are painted in a very dismal way because researchers are only asked about the negative stuff, not about potentially positive stuff. So, I mean, and that's a big kind of claim. But I think if you kind of ask, what's distressing about your job, do you find the caseload overwhelming? And it's kind of really easy to agree with all of that. But if you ask some positive question, ask what's positive, you can get a much more nuanced and complex picture. So I've used the concept of job satisfaction. So at that kind of more concrete applied level of using concepts which do have a theoretical heritage, I think has been a kind of easier way to get into the field. I mean, of course, and many people have written about this, and I think probably Nicholas Luhmann is the one that puts it out there kind of in its simplest and most direct way, is that we're dealing with different systems, and different systems are not good at talking to each other. And in particular, law is not good at it kind of hermeneutically seals itself off from other disciplines. And so it can be very difficult to show relevance to law of social science, for example. I'm sure this is the case also in medicine. And so it's important for us as social researchers to use the language of law or the language of health and medicine, rather than expect law and medicine to use kind of sociological language and concepts. So I guess it's kind of interesting, and I have often kind of thought about the difference between law and medicine, and the kind of the health world, the medical world. Health sociology seems to be more open to social research than the legal world, and that's again another big claim which is perhaps contestable. So I guess one of the things in terms of a career is that when I have some data, like very early on in my collaboration with Kathy Mack, we did a piece of research on guilty pleas, and it was a piece of commissioned research for the Australasian Institute of Judicial Administration. And they really wanted to know about what's known as plea bargaining, but I can talk about that later. It's not really plea bargaining in Australia. You know, we've all seen those American TV shows where, you know, the prosecution and the defense and the judge are all kind of figuring out what to do for the defendant, and you kind of think, well, this all happens behind closed doors. The defendant doesn't seem to have much autonomy in this situation, and truly that's the case. So, and I was we were very careful to negotiate the data, that we did a number of interviews with various people in and around the criminal justice system, and we negotiated use of the interviews for our own kind of purposes, so that when we wrote the report, we could provide the kind of report that would be appropriate to the audience. I mean, I think we always have to be aware of who our audience is. So provide it in a form that the audience could find useful, but also allow the scope to have some academic publications and be able to talk about the research literature, be able to talk about the theories much more broadly. So we had kind of two audiences, the academic scholarly audience, as well as the kind of more applied practitioner policy making audience. I mean, it is very difficult to straddle. And this research was conducted kind of a long time ago, and the world has shifted. So I think it's even more significant to be able to do both. Now, Sophie, you might have had, I'm trying to jot down notes from the questions so I don't forget them, but you might have had another question in there as well, Sophie.
No, thank you. It was interesting. It was good. I particularly liked what you said about how certain disciplines are maybe more amenable to different languages from different disciplines. I can definitely relate to some of those tensions. But yeah, it's about tailoring the message. And I mean, for my particular thing yesterday, it was a very brief presentation, and I was specifically told not to include any of that stuff, because they just needed to know what they needed to know, so
exactly
they could do what they needed to do.
Exactly.
Yeah.
And that's important. And I guess also credibility is important. It did after I did my PhD, I came to Australia. I did it overseas, and I looked at women in the legal profession, and I was kind of interested in doing more research in and around law. And it occurred to me that it would probably be a good idea to do a law degree, which is what I did. And so that opened up some more doors that would not have been opened if I did not have a law degree.
Were those doors open because of networking, or just because you're talking about credibility in terms of asking questions and conducting research?
That's a great question, Sally. It's right time, right place. So, okay, so I was doing my law degree part-time, and I mentioned earlier this project that I'd done in collaboration with Kathy Mack on guilty pleas. And she was an academic at Adelaide University, where I was doing my law degree part-time. And she was aware that I had a PhD in sociology and had done work on the legal profession in the US. And so when somebody contacted her, was she interested in doing a piece of research on guilty pleas across Australia? So this was going to be Australian-wide research. She decided that she did want to do something more than doctrinal research. That is, she wanted to do something more than look at the decided cases and the law on guilty pleas. And she wanted to do some empirical research. So she asked me whether I'd be interested, and I said yes. You know, I was I don't remember what year. Exactly, but I was kind of at a hiatus in my research. I'd finished publishing out of my PhD, and I thought, well, this is kind of an interesting opportunity. So that was the beginning of our collaboration, and our collaboration, which is quite an old one. We have been working together for, well, the first time we worked together, I was pregnant with my first child, and he is now 26. So this is a long and quite, an enduring collaboration. So, and she said to me later, and we have reflected on this, how come the collaboration has continued for such a long time. And I think she asked me because I had studied law. At that point, I'd finished the law degree. So I was no longer a student at Adelaide University. I had finished the law degree. And so she felt, and this is right, there's just, yes, sociological naivety is fine up to a point. And that's what I always kind of understood, in my early days of doing empirical research, that the sociologist was in a unique position because you could ask the naive questions, in quotes naive, which really weren't naive, but they were the taken for granted things that people in workplaces or organizations or situations kind of took for granted, didn't think about, just thought everybody knows. But when you start to ask, okay, well, why do you do it like that? Or how is this happening? You realize that it's not shared among everyone, or people do have different takes on things, or it's not as naturalized or normalized as participants in the actual social setting think it is. So I think it is important, especially because, again, I think it's partly because of the adversarial legal system, and lawyers by nature in the system are argumentative, and sometimes they like to show off how much they know. We all do, don't we? So just having the right language. They don't work in offices. The judges don't have an office, they have chambers. So if you say, well, let's go down to your office, or shall we meet in your office? Well, you are an outsider. Yeah. We're going to meet in their chambers. So it was important for credibility. It was also right time, right place. It was also that, that Seneca view of luck, which is, preparation meets opportunity. I love this quote from Seneca, that there's no such thing as luck. Because we often say, well, I was so lucky, just had a lucky break. Well, no, it's preparation meets opportunity, and, picking an opportunity if you can.
Yeah. Thank you. We've actually got a participant today who is currently driving in California.
Oh, my goodness.
Exiting a national park there, and she has asked a couple of questions in the chat. She would like to know if you could speak a little bit about the methodologies you've used to capture the judges' attitudes. That's one of the questions she's asked.
Okay, so I've just opened the chat, and this is Maricela.
Yes.
Hello, Maricela. Where do you start? Well, I can take the easy way out, because I think it's a really important question. I can take the easy way out and say, Maricela, if you would like to email me, I can send you some of our publications, which we've talked about our methodology. So the first piece of research that I did, and I'm just going to talk about the research with courts and judges. There's some other things, other research projects I could talk about, but because I'm so immersed in courts and judges, I will stick to that dimension unless somebody wants to steer me in a different path. Okay, so part of the methodology is also tied to the biography of the research, and that is a bit of a long story, which I can go into, but I don't need to yet. So the first piece of research that we did was in 2002. Well, actually, before that, we did some in-depth interviews with judges and magistrates around Australia to just get a sense of what they saw as issues and challenges facing the judiciary. One of the things we wanted to be careful about is that our findings would be of interest and use to judicial officers. And so we kind of had some seed funding to talk to judges and magistrates to see what they thought was kind of going on, what were some of the issues, rather than us kind of coming in cold and just kind of creating fictions about what we thought were the issues. So it was kind of collaborative to start with. And we did a survey of all magistrates in Australia. So all up, there's about 1,000 judges and magistrates across Australia. So it kind of didn't make sense to do the usual sample survey. And so our first study was just of magistrates, so lower court judges. And so our lower court judges are called magistrates. And they're different to magistrates in England and Wales. So we sent a survey to all 500 and got around a 50% response rate, which we thought was just terrific. Like we couldn't, I just thought 50% of judicial officers responding to a survey is a kind of a terrific outcome. And we asked a lot of questions. We asked about career background, the kind of skills and qualities, job satisfaction, demographic questions. So we had kind of 6 main areas of questions. Then we were kind of interested in the way in which magistrates delivered decisions, and we did a whole lot of court observations. So Kathy and I sat in courts around Australia, recording what we observed. And we observed a total of 1,287 matters across Australia. And we also were able, in most cases, to get the court transcripts of what we observed. So we had the paper version of what we saw and what we had coded. So that was a kind of a complicated study. And then we did another round of surveys with magistrates and judges. And then we did a study that looked at social change in the judiciary, and we relied primarily on interviews. So pretty open-ended interviews with a series of kind of subject areas that we wanted to cover. And one of those subject areas was the emotional dimensions of judicial work. We also looked at social change and judges and magistrates' perceptions of changes in the courts, and more about some of the challenges in and around the courts. And we looked at emotion. We also looked at kind of work-family balance. So some of those questions we had in the surveys, and we kind of transferred them to the interviews to be able to have a more of a deep dive into magistrates and judges' experiences, their approaches, their perceptions, about what they're doing, about their role, about their situation, about some of the, the kind of the difficulties and the benefits or advantages or positive dimensions of being a judicial officer in Australia. So there's lots of different studies within this kind of 20-year band of research that's looked at judges, magistrates and their courts across Australia. We were very clear we didn't want to focus on one jurisdiction. We wanted to try and make this a kind of national study. I have to say, of course, we were fortunate to have funding to do this. So it's very difficult, impossible really, to conduct empirical research without some funding. Maricela, now, are there any other dimensions that I can elaborate on for you?
The other question I can see in the chat is the, and whether, do you publish your findings in legal journals or sociology type journals?
Okay. Oh, and thank you, Sally, for popping up that important article of ours. Thank you. Okay. And yes, Maricela, I'm very familiar with the International Society for and Therapeutic Jurisprudence and Procedural Justice. So I'm very familiar with those concepts and some of the research that's been conducted around therapeutic jurisprudence and procedural justice. Okay, where to publish? Oh, that's a really good one. We've tried to do both. So we've tried to publish in outlets that are specifically targeted to judges and members of the profession. We have published in various newsletters. Of course, some of these, and it's only in the past, I suppose it's 10 years now, that the universities have really, well, at least in my experience, I mean, it's perhaps, it happens at different points in time at different universities, but in my university, we really only in the past kind of 10 years or even less, that there has been this big push to publish in tier 1 journals, and that there's been all these metrics around where you should publish and what you should take into account when you make a decision about publishing, etc. and etc. So, and then we've published in kind of socio-legal, I think probably socio-legal journals more than straight mainstream sociology journals, although of course, our JOS article was a real treat, and that was a kind of great outcome for us. And that's probably one of the few kind of straight sociology journals that I've published in. So mostly socio-legal journals. Of late, and this is something I would advise early career researchers not to do, is lately we've published a lot of book chapters for people's edited books, simply because people have said, would you write a chapter? And we've said, yes, we'll write a chapter. So we've got like 4 in-press book chapters about to come out. And I wouldn't recommend that for early career researchers, but there's all kinds of reasons why you say yes to writing a book chapter, and I can kind of talk about that at length. So we've got, and we've got a couple of books. So I mentioned our books coming out early next year with Routledge on emotions and judging. And a couple of years ago, I did a book, which was, and again, I interpret this as it was a point in my career and I could afford to do it. I know many early career and mid-career academics have to be very strategic in the kinds of things that you say yes to these days. And I had a lot of fun editing a book. Well, sometimes it wasn't fun at the time, but looking back, I've reinterpreted it as a lot of fun, editing a book on humour and judging. And that book came out of being of the Australasian Network of Humour Studies, was having its conference in Adelaide, and we had a little bit of data on humour in all our kind of huge amounts of data. We had a little bit of stuff on humour, so we wrote an article and gave a presentation. And over morning tea, I was talking to one of the leading scholars in that network, and we were chatting about kind of people that we'd worked with overseas on judges and courts. And then we had one of those moments and we said, oh, we could edit a book on this, an international edit collection that looks at the question of judging and humour. And we did it. And she's in English literature and theatre studies, and I'm in sociology. And we kind of did this wonderful kind of cross-disciplinary collaboration, which was a lot of fun. And that's another big kind of set of issues around the role or use or relevance of humour in a judicial context in the courts. And there's a silly me, I thought, oh, okay, here's a new set of ideas. We're going to be pioneering around humour and judging. And the metaphor that I have is like being in a big hotel and you see the door, humour studies, and you think, oh, well, there's going to be no one in that room. and you open the door and it's crowded with people, and you think, well, this is whole area that kind of intersects with sociology, but I hadn't been really aware of it. Well, I hadn't been aware of it at all, and it was just kind of terrific, and it just opened up a lot of new sociology. There's some great sociology of humor. When you're thinking about the workplace context, when you think about any workplace, humor, joking and laughter are huge issues and are huge social issues, and it provide very kind of interesting insight into the working of ordinary everyday organizations and workplaces.
That's really interesting.
Oh, and another spruik. I've done a podcast for the Academy of the Social Sciences, which hasn't been yet, looking at humour and judging.
Well, I'll get in contact with Chris and ask for him to send me the link to that. We'll pop that in the newsletter, and I can include that in the recording, your forthcoming book and a few other links in the recording. This has been great. We do have Zoe's asked a question. Did you encounter any resistance to talking about emotions and emotional labour in your interviews? Did the emotion rules governing judicial work impact on interviewees' willingness to talk about their emotional labour and difficulties in this area? And was this gendered?
Oh, that's a lot of questions. That is a lot of questions. Okay, what's the first part? Well, okay, all right. So I did all the interviews myself with 38 magistrates and judges across Australia. Most people that I contacted agreed to an interview, some did not. Now, I'm not sure about whether I want to use the term resistance to talking about emotion and emotion work and emotional labour, but perhaps what I would say, and again, this kind of goes back to the idea that as sociologists, we work with scaffolding around our concepts, and the judges and magistrates didn't have the same scaffolding. So I think some of them might have found it difficult to talk about emotion and emotion work because they didn't have the language to do it. In part because the work of law is cognitive. They're about thinking and not feeling. And sometimes when I looked back at the interviews and they talk about thinking about this and thinking about that and thinking about something else, I could almost have just as easily taken out the word thinking and put in the word feeling, and it would have made just as much sense. So I think they don't have the scaffolding that a sociologist would have, and they don't think about their work or feel about the work in the same way. There's a very strong socialization process in law to remove emotion and to think that it's a cognitive process and that it's rational. And they adopt a very classical view of emotion, that there's rationality on one side and irrationality on the other. There's thinking and there's emotion, and they are two separate things. So they kind of work with that kind of cognitive approach to emotion. And of course, if you've read Sociology of Emotions, and in particular, a book that I love is Lisa Feldman Barrett's book on how the brain works. I think that's what it's called, or something like that, who talks about the kind of intertwining of cognition and emotion. The just kind of don't think, or they haven't thought about the world like that. So, and in terms of the interviews, I interviewed men and women, and they all were pretty reflective on the role of emotion in their work. So I'm not in a place to draw some clear gender inferences, although there were some instances where women talked about trying to really not express emotion in the courtroom, whereas some men said, well, if I show this emotion, it probably is a good thing. It won't detract from my authority, whereas I get the sense that some of the women think that if they showed particular emotion, that it would detract from their role as an authority figure. But I am very uncomfortable then inferring from those instances that there's a gender difference. I mean, I think the overall socialization process of being a lawyer and a judge puts emotion in a particular place, and they can talk about emotion in that way, but not in a way that a sociologist will talk about it. Although, of course, some of the things that they talked about were just dripping with emotion, but they didn't use emotion language or emotion concepts. So I think it's kind of interesting and complex.
Very interesting. We've actually, someone's just put a new message, but yes, Zoe has said that was really interesting with an exclamation
mark. Thank you, Zoe. Oh, well, thank you. Thank you. Thank you for joining.
We have come to the end here, but Dan's heading off to another meeting and he's saying thank you. I'm really grateful. That was exactly how our TASA Thursday casual chat with a distinguished sociologist, that's the concept that I had in mind. So you've worked that really well.
Oh, Sally, thank you. Well, thank you for your perseverance.